I'm David Berry with Berry Law in Overland Park, Kansas. In this video, I'd like to share a little bit about the tools that are available to assist you in the event of incapacity. Imagine if you were incapable of managing your affairs due to an injury or illness. Whether that be trauma, such as a brain injury, or a medical condition like dementia, each of us faces the real possibility that we could become incapacitated during our lifetime. Capacity means the ability to understand the consequences of our decisions and actions. An incapacitated person may have difficulty receiving and evaluating information, or they may have difficulty being able to effectively communicate their desires and decisions. If you're incapacitated, you may find it difficult to effectively manage your financial affairs or meet your essential needs, such as your health, your welfare, and your safety. If you became incapacitated, who would have the authority to act on your behalf? Who would have the ability to protect your interests? Well, it depends. Do you have powers of attorney? A power of attorney is a legal document in which you can appoint somebody to have the authority to act on your behalf if you should become incapacitated. There are many different types of powers of attorney, so it's important for you to understand whether the powers of attorney that you have will provide you the levels of protection that you need in the event of incapacity. Be sure to watch our video on powers of attorney for more information on this topic. Having powers of attorney in place may really help you if you become incapacitated. But what if you don't have powers of attorney? Or what if the powers of attorney you have do not provide the levels of protection necessary? In that case, it may be necessary to establish a guardianship or conservatorship. A guardianship is a legal process in which a person is appointed to take care of your personal needs, such as your health and your welfare. And a conservatorship deals with money. So during a conservatorship process, a person's going to be appointed to deal with your money and your finances, to pay your bills and keep your accounts. Getting a guardianship and a conservatorship can be difficult and challenging. A guardianship conservatorship hearing involves litigation where a court declares you to be incapacitated and then removes your rights to transact business and make decisions for yourself. Once those rights are removed, they cannot easily be restored. Most guardianships and conservatorships that are implemented on a person when they're adults remain in place until the person dies. So this action, it cannot be taken lightly, and the court must ensure that due process is met. This means that a judge is going to make sure that you have a right to qualified counsel, that you're notified of all of the hearings, you have the right to attend those hearings, and you have the right to challenge and put on evidence. So the first thing that's going to happen in a guardianship or conservatorship hearing is that the judge is going to appoint an attorney called a guardian ad litem to watch out for your best interests. Sooner or later in that process, there will be a hearing where evidence will be put on. You can expect that there may be medical professionals that will testify as to whether or not you have capacity. And in the end, if the judge determines you're incapacitated, someone, a third party, will be appointed to serve as guardian and perhaps conservator. Now this could be a family member, it could be a friend, or it could be somebody the court appoints. Once those individuals are appointed, they will remain in that position and be answerable to the court. On a periodic or annual basis, they will need to file reports with the court explaining what's going on about your medical condition, your capacity, and perhaps your finances. Now, anytime you have a court involved in anything, anytime there's litigation, it's time-consuming and costly. There will be scheduled meetings and hearings. There will be filing fees. There will be attorney's fees, guardian ad litem fees, perhaps fees for expert witnesses, and a fidelity bond. All these things add up and can be very expensive. Indeed, sometimes a guardianship or conservatorship hearing and proceedings can cost several $1,000s. At Berry Law, we believe that it is important to plan for your incapacity as a part of your overall estate plan. After understanding the costs associated with guardianship and conservatorship proceedings, most of our clients want us to put into place powers of attorney that will protect them in the event of an incapacity. And we believe that any adult should have these documents in place. In closing, a word of caution. Powers of attorney, guardianships, definitions of incapacity or capacity are all state specific. So it's important that you consult with qualified and competent legal counsel in your state before drafting or signing any powers of attorney. If you live in Kansas or Missouri and you have questions about powers of attorney or guardianships, please feel free to contact Berry Law, and we would be happy to answer your questions and assist you with your estate planning needs. Our number is 913-336-1600. Finally, if you like this video and found it to be informative, please click like and subscribe for additional videos and notifications in the future.